Hi, my name's Sean Good. I'm an attorney at the Good Law Group. In this video, we're going to talk about how vocational experts, or what some people call vocational witnesses, impact your Social Security hearing. So the first thing you should know about the vocational witness or the vocational expert is that they're present at just about every hearing. I don't think I've ever actually had one where they're not present. I have had hearings where they aren't really doing a lot, but 99% of the time they're very important and they're present during the case. So their role as the vocational expert is to first classify your past relevant work. And the definition of past relevant work is work you've done full time in the last 5 years. Now in 2025, this definition changed. It used to be 15 years, but it actually benefited claimants or my clients when they changed it to 5 years because it limited the past relevant work period. So Social Security's vocational witnesses, they're independent, and their job is to look at what you wrote in your work history form and listen to what you said about your job and classify it using the Dictionary of Occupational Titles. And that's just what it sounds like. It's a dictionary of jobs. So you're going to hear them give a DOT code, that's a 9-digit code, and it'll read like something like 624-187-010. It's sedentary, it's SVP5, and those things are, they're talking about the physical demand level going from sedentary, light, medium, or heavy, and the SVP being the specific vocational preparation, which is 1 through 8, and those are the skill levels and how long it takes to learn the job. So after the DOT job classification is made by the vocational expert, the vocational expert's going to respond to the administrative law judges and your attorneys hypothetical about what your residual functional capacity is. And the definition of residual functional capacity is the most work you can do despite your limitations. So I'll just give you an example. So you're going to hear a judge say, assume you have an individual with the same age, education, and work experience as the claimant. Further assume this individual is limited to light work and they can only use their hands occasionally, and they should never stoop, bend, kneel, crouch, and crawl, and they're going to need 5-minute breaks every 3 hours. And that question will be asked to or presented to the vocational expert. That hypothetical will be posed, and the vocational expert will respond, can they do their past relevant work? Are there other jobs they can do? And depending on their age, are there transferable skills that an individual acquired at their past work? So those are kind of the main roles of the vocational expert, and it's very important to have an attorney there and know what they're doing when they're talking to the vocational expert, because the way these vocational experts can respond will make or break your case. If someone just sits there and ignores what they're saying and doesn't understand, how SVP, your work history, your age plays with the outcome or the likelihood of you being able to work or not, can really be detrimental to your case. The second thing is, a lot of the time, the Dictionary of Occupational Title, the book of jobs I told you about, is wrong. It's very old. It's last updated in like the early 90s or late 80s. And you're hearing a lot of vocational experts change testimony, or rather change the definitions in the book. And you really want a lawyer that knows what's going on with the DOT, what vocational experts are doing consistently at these hearings, and are ready to ask them questions to protect you and get you those benefits. Thank you for watching this video. If we can help you or a loved one with your Social Security case, give us a call at 800-419-7606.